Hello and welcome everyone to yet another edition of MHQ's Foundation 101 podcast, where today we are talking attack and defense. But no, we're not talking football. We are talking fiduciary structure under attack. And for that, I have the head of ME dispute, my friend Stuart Patterson, who is joining me. Stuart, good morning.
Good morning, Jan. Thank you for hosting me on this podcast.
So make no mistake, I thought we were not talking about football, but at some stage we are. People like us at MHQ are here to devise legacy planning, business protection, and asset protection structure and help people administrate them. People like Stuart, they either advise people or they do the nasty bit, they attack them. So Stuart, in a way, is like the Lionel Messi of attacking fiduciary structure. He's excellent at it, which is why we pick up his brain today to check the do's and don'ts when setting up and operating fiduciary structure, particularly when talking about asset protection. So Stuart, before we put that into context, we know that a fiduciary structure can be under attacks from creditor, from spouses, from beneficiaries, from disgruntled heir. But perhaps the worst attack of them all is public opinion, is the media that often vilified foundation trust and other legacy planning structures. So my question to you, just to kick off, is it fair that these structures are vilified in today's world?
Yeah, it's a really good question, Jan. And just to go back to your first point, I think I'm more of a Harry Kane than a Lionel Messi. But in terms of your but in terms of your question, I think it's absolutely right that trusts and fiduciary structures have just got a really poor reputation in the court of public opinion. In particular in the UK and other countries where there are very high rates of personal taxes. They're widely seen and simplistically seen as vehicles to hide property, to avoid taxes, otherwise to conduct your affairs furtively behind closed doors in a faraway island, offshore jurisdiction, and probably for unlawful purposes. And I think they're also associated with the young and idle rich who live a champagne lifestyle and live off the proceeds of a trust fund established by their hardworking prior family generations. And these colourful impressions have been made even worse, exacerbated by leaks from trust companies, law firms, etc., such as the Panama Papers leak, where information about really high-profile individuals, politicians, etc., using offshore structures and trusts have emerged, and details of the vast sums being put into them have come out as well, which really hasn't helped. But I think that's just not the whole picture. Trust structures have been used for times going back to the Roman era to manage wealth, to pass wealth down from generation to generation, and for perfectly lawful purposes. Trust structures are used not necessarily for avoiding taxes or for hiding money, but for, as I say, for perfectly good reasons, for succession planning, for lawful or legitimate privacy concerns. And we shouldn't forget that these days, trusts are a key foundation stone of the perfectly legitimate financial services industry for managing pensions and other financial investments as part of the broader financial services landscape. And similarly, for charities, the activities and structure of charities are based upon trust structures in many cases. And without getting too legalistic about it at this introductory stage of the discussion, just this year, the English High Court made a very clear comment around this point. The court stated, the use of complex offshore corporate structures or trusts is not, without more, a ground for believing that they've been set up or are being used for wrongful purposes. There are lawful reasons, privacy, security, tax mitigation, why very wealthy people invest their capital in complex offshore corporate structures or trusts. So I think going back to your question, it's entirely reasonable to say that the mere use of a trust or a foundation should not be something that raises suspicion automatically. But the many examples, unfortunately, of wrongdoers flagrantly misusing trusts has inevitably damaged their public perception.
So you mentioned the potential illicit or the potential improper use of fiduciary structure, whether trust or foundation, damaging the general perspective that we have on this industry. Give us some examples of improper use of a fiduciary structure, whether trust or foundation.
Yeah, thanks, Jan. So this is where the footballers, on the attack come into play and start to find creative ways of getting money out of trusts that have been put into them for possibly unlawful purposes. So a good example was a Cayman court case. So Cayman is a very common place for establishing trust-related investments. And it related to a settlor, so a person who put the money into the trust, and who later became insolvent following proceedings in which he was found to have misappropriated money from a Turkish bank. Mm-hmm. And as we know, it's not uncommon for the settlor to reserve to himself certain powers in connection with the trust, for example, to add or remove beneficiaries. In this case, the settlor placed assets into the trust with himself and his wife as beneficiaries. However, he reserved the power to himself to revoke the trust at his own discretion. So he could therefore take out the trust assets, take them back to himself at his own discretion. So creditors came along on the basis that the Cayman court could grant to a receiver an equitable execution order over the power of revocation. So quite a clever idea. So in other words, exercising this power to revoke or collapse the trust could be given to a third-party creditor rather than just exercised by the settlor himself. And the court granted that order, and therefore the receiver was able to exercise that power of revocation and access the trust assets.
So this is typically a case where,
way.
Yeah. So this is typically a case where too much power, too much control is detrimental to the purpose of the structure and to the interest of the settlor and beneficiary, right?
Absolutely. It didn't mean that the trust was in any way deficient. It just meant that the settlor had left himself exposed by keeping this power, because in this situation, it could be exercised by a third party following a court order. And that was ultimately determined by the Cayman court, but then it went up, in fact, to the UK Supreme Court. So a good example of trying to do too much and it coming back and having the opposite effect for you. So those assets were then exposed. And then another example we've seen recently where some creditors were closing in on a particular individual. He then decided as the sort of the D-Day got closer to give up all of his powers as settlor of the trust. So as to prevent exactly this happening, so to prevent a receiver or a trustee in bankruptcy being able to step in and exercising those powers on his behalf. And so what he did instead was to assign those powers to third party, to the trustee in particular. So these powers were handed effectively over to the trustee. The settlor no longer held those powers. And this, he thought, would protect effectively the best part of $3 billion worth of assets from creditors coming after them. But it didn't work. And it didn't work for two particular reasons. Firstly, the instrument needed to make some of these changes, in particular to change the beneficiaries, had to be done by deed, a formal and legal document with witnesses, etc. And it wasn't done that way. It wasn't done with the correct formalities, so it was of no effect. And secondly, some of these powers that were originally held by the settlor and which were being transferred over to the trustee, such as the power to remove the trustee, were not ones that could be handed by the settlor back to the trustee. It just made no sense. And so when looked at in the round, it was clear that these changes were not effective. And so the attempt to protect himself from the creditor's challenge of the trust was unsuccessful.
So clearly that would be one case where one would have benefited from a little bit of advice from one Stuart Patterson, right?
Or one
preemptively.
So quite.
So these are two great examples of improper use of over control, and we'll show that illustratively in no time. What about the illicit use of trust, often referred to as sham or illusory trust or foundations?
Yeah, no, so that's another type of situation where what one does goes wrong. So, I mean, there are lots of examples of this. There's one highly publicized example of 2 or 3 years ago, the Pugachev case, where a long trust deed in place, which looks legitimate, lots of provisions that suggest that all are consistent with an ordinary and proper trust. But in fact, the parties do not necessarily intend that it should have the effect that, looked at objectively, it in fact has. So in summary, this is quite a complicated case, but in summary, what the judge said is that if you were to look at the way the trust worked, even on paper, so suggesting in fact that it doesn't actually have to be a sham, and review all of the powers that everyone involved has, which in this case was all the powers the settled law had, and grouped them together and looked at them in their fullest extent, you'd come to the realization that the beneficiary is still in control of all of the assets and not the trustee. So in this case, the judge looked at things like who can decide who is hired or fired as a trustee, who can decide who gets distributions out of the trust fund, who can decide on investments and what happens to trust assets, who can add or take away a beneficiary. When you look at all of that in the round, it begs the question, what is being left for the trustee to do if all of these powers are being in some way reserved for the settled law? Is the trustee acting as the legal owner of the trust property? And the conclusion in this case was that the individual settled law had not really given away anything, as he still had, despite this very lengthy trust documentation, control of all of the assets largely to the same extent as he had before. So while it wasn't technically a sham trust, as it did what it was supposed to do in writing, it didn't in the round have the legal effect that was intended. And you could therefore look through the trust and see that in fact the settlor still had control of his own property.
So we talk here about going beyond the line of asset protection. And this line is often referred to as a firewall provision. In other words, it is the line of defense provided by a trust or foundation regulatory framework to protect settlors and beneficiaries and their assets from attack. So my question to you about these firewall provision, if you can touch a little bit on that, their benefits, but also their limitations.
Yeah, it's an interesting point. So there are surprising limits actually on the effectiveness of many asset protection vehicles, depending upon the jurisdiction or the country in which the trust has been set up and where the assets are located. So different jurisdictions have different levels of asset protection built into their legislation. So many of the offshore countries which have a trust industry have set up in their trust statutes provisions that effectively mean that any issue concerning the setting up of the trust has to be determined in the home court of that country. So if it's a Jersey trust, it has to be dealt with in the Jersey courts. It also tends to be the case that these courts are quite faithful to upholding their own trust structures, because of course that's in their national interest. And these types of laws are sometimes called, as you say, firewall legislation or firewall provisions. And they attract a lot of commentary as they're seen as an additional layer of protection around the trusts. And to some extent they are. But again, that protection can be quite limited on a case-by-case basis. So to take an example of where the protection is significant, some jurisdictions have very aggressive firewall legislation, and the Cook Islands is a good example. So the Cook Islands are very famous, notorious, you could say, for having strong asset protection structures or supporting them. There's a concept of an insolvency clawback or look-back period, which is where if you have transferred money into a trust or a foundation, and you then go insolvent within a certain period, the court can effectively render void that transfer, so the assets can be made accessible to a creditor. And so in the Cook Islands, that period is only 12 months. So after 12 months have passed from putting the money into the trust, then that money is safe from any future creditors. So that 12-month period is seen as being very aggressive, and it's irrelevant as to whether the cause for the attack on the trust is simply insolvency due to misadventure in your business, or whether it's due to, say, fraud. It doesn't matter. So that's a pretty aggressive example of a firewall protection piece of legislation. But the problem with all of this is that in many ways, it's only really as useful as where the assets are located.
Yes.
Because the trust is in a way just a wrapper around the asset. So if the underlying asset, whether it's cash or property, is sitting in, say, London, but you've got a Bermuda trust law set up in relation to it, you may have problems in Bermuda if you try and attack the asset at that level. But you've got a reasonably good chance as a creditor if in fact you go first instead to the courts in London to try to access that asset. And you may well expect to get a better outcome there, not least because the legal system is perhaps more balanced. So it's only necessarily as good as the place where the assets are located. And as you know, perhaps in summary, you would not be surprised to hear, many of the world's most wealthy individuals are not particularly keen on placing all of their assets in the Cook Islands.
Which is also one of the reasons why of late, most of the tier one financial centers and super jurisdiction like the US, UK, Switzerland, Hong Kong, and the UAE have been doing very well in terms of legitimate structure that are very robust and that can be controlled by family within an environment that is credible. Because the social stigma of using some of these slightly lesser reputable jurisdiction is something that is important to families, for sure.
That's right.
I wanted to show and to rebound on what you said before about this line of control, and maybe to put it in the concept of foundation. So if you recall, foundation, very similar to trust, they have a founder that sets up the foundation. They are controlled by the council members, and oftentimes there is some additional right vested upon the founder or the guardian. So where does the control lie in a structure like this? It is predominantly and often with the council members pursuant to the bylaws and the charter. And this can be very flexible, can be defined by the founder upon inception. But some additional rights can be held over time, either still with the founder and or the guardian, the protector of that structure. And we call them reserve powers. You touch upon it, and they can be a vast menu of these. They can be very tiny, and they can be a lot of them. So maybe to recap what you said before, how much is too much in a structure like this? Does it depend on the purpose of the structure? Because we see a lot of patriarchs today setting up trust structures in the Middle East predominantly for legacy planning aspect, where asset protection is not necessarily the key objective. So how much is too much?
Well, it's a really good question, Jan. I mean, in some ways, there might be a single power that just means that in reality, the structure doesn't work, and therefore it would never have the effect of transferring or separating the beneficial interest. But I think more often it's going to be the case that if you look at these powers in the round, you would form the view objectively as a court that there hasn't been that separation. So that's more likely to be the case. So to answer your question, it depends. That's what you'd expect a lawyer to say. But I would say that's the best way of summarizing the answer. You look at it all in the round, and if there hasn't been that clear separation, has the settlor actually given up control, then you would say it's too much.
And that is clearly from most importantly an asset protection standpoint, because from a legacy planning standpoint, this is not an object here. Now, if we look at a threat, and we've seen a lot of these come into life, unfortunately, over the past 12 months, can be attacks against the business, can be attacks against the entrepreneur. You mentioned that before. Is there a timing issue with that, and how early should one consider setting up a robust holding structure before a potential event occurs, typically a business going down or someone claiming a personal guarantee against a person?
Yeah, I mean, there's a whole host of considerations here. I mean, clearly, at a sort of higher level, you wouldn't want to necessarily be transferring your assets into a structure until you've decided that just from your sort of commercial business and family perspective, it makes sense. And then once you do that, you need to be getting advice around that. Then you need to be thinking about whether there are any sort of other timing issues, such as if you are at risk in any way of being insolvent in respect of one of your businesses, whether that has an impact. So there are a whole host of timing issues to think about.
Yep.
But very clearly, if you do move assets across within an insolvency look back period, then it may be of no effect to do so. You may be putting in place an expensive mechanism that has no legal effect. So there are a whole host of considerations to think about rather than any single one. But this is where I think it's really important to get advice from specialists in this sector.
And I'll second that, boss, because when you do that, you think, okay, I'm going to set up my assets onto a foundation. It's easy. I'll have someone else run it, and then my assets will be protected, right? But due to timing reasons and opportunity reason, this green protection may end up being pierced. It's rare, but it is possible. Thus the importance of taking advice, and perhaps the 3 takeaway that we agreed to put here forth. So maybe, Stuart, I can let you work against these 3 so that people walk away with something useful. If you are to set up a fiduciary structure, these are the ones.
Yeah, this is my Harry Kane hat trick. Yeah,
exactly.
So we'll start off with the rationale. Absolutely critical. Why are we doing this? Does it really make sense, or have you just been sold something that's not going to fit for your circumstances? You need to have clear objectives for setting up a structure. Secondly, you need to then assess, once you've decided to do it, the three or four key things. What is it going to be? Is it a trust? Is it a foundation? What are you looking to put in place, and why? And is that the right solution for you? Where is it going to be? Are we going to be going off to the Cook Islands or somewhere more sensible in terms of the objectives that you're looking for? And then the provider, you use a reputable professional trust or foundation services provider. Absolutely critical to make sure that it's implemented and structured correctly.
And maybe just on this one, on the tool, so many times we have people, hey, I want a DFC trust. And I said, that's great, but why? And people say, yeah, I want to structure my real estate under it. I say, yeah, that's not possible. Today, you need to actually do a foundation, and you could put a foundation in conjunction with a trust, but you cannot just do that because the land department would not accept it. So people say, oh, okay. So this simple question just changes the parameter a little bit. You're right. That's the importance too of your 3rd takeaway.
Yeah, no, completely. I mean, again, you really can't do this without getting good advice and also not just from your professional advisors, but knowing who the people are that are going to be carrying out the day-to-day and longer-term services in relation to the structure that you're putting in place. The trust services providers, the council that's going to be administering the foundation. So that control and governance element is absolutely key to ensure that your structure is set up correctly and then that it operates in the future correctly.
Thank you very much, Stuart. That was, I think, a deep dive into how these structures not only function, but can evolve over time and possibly be fragile if you do not pay attention. Thus, the importance of seeking guidance initially and then reviewing this guidance, because circumstances can change. So always the importance, like for a football player, take him out, stretch him a little bit, and then back in the game. Next week, we're going to be talking ultimate beneficial owner regulation and impact on foundation, notably with some of the frequently asked questions on the topic, hot topic. People should have complied already here in this jurisdiction, and privacy is always a hot topic for families. So that's what we'll cover with Kat Zagati. Stuart, thank you very much, and you have a good day. We'll see you soon.
Thank you, Jan, and you take care. Bye-bye.